All right, ladies and gentlemen, welcome back to Truth to Power podcast. As always, I am sitting with attorney and executive director of New Energy Economy, Mariel Nanasi. Thank you for joining us.
My pleasure.
We've had so much going on. I feel like that's how every episode starts. I'm like, oh gosh, okay, what are we talking about? So much is going on with New Energy Economy right now, and I guess most of our listeners and also followers online are really interested in Rate Case.
So we're going to start there.
So let's start with Rate Case. Let's go into that. What's going on with that realm of...
So many of you know that we were involved in a 3-week Zoom hearing, which is quite intense, for, almost 8 hours a day. And then following that comes briefing. So I'm just telling you the process of it. So we all file briefs in chief, which are post-hearing briefs. And then about 2 or 3 weeks later, as is the regular course, we file response briefs. So we read what the opposition says and we respond to that. And then the hearing examiner issues his or her recommended decision. Following that, we have 2 more rounds of briefing, and that is called exceptions and responses to exceptions. And exceptions are like, what do we object to in the hearing examiner's recommended decision? And so then, presumably, the commissioners, in this case, there's only 2 presiding commissioners because New Energy Economy moved to recuse Commissioner Patrick O'Connell, and he did, in fact, recuse himself. So there's only 2 commissioners who will be deciding this case ultimately, and they are Commissioner Aguilara and Commissioner Ellison. And both of those 2 commissioners did involve themselves at times to ask questions and also just to listen to the testimony that was being provided online. So that's just sort of like the way it goes. And then there will be a meeting, an in-person meeting that could be viewed online, and the commissioners will talk about the issues, and then they will issue their order on the rate case, and there's lots and lots of issues. Just so you know, PNM's brief was like 300 and something pages, but New Energy Economy's brief was 117 pages. So, and they had a lot more issues than we did. We focused primarily on a couple of things that I'd like to talk to you about today, and the big ones are this. The first thing is that PNM asked to have their gas plants depreciated over a different schedule than was previously designed. So think about your house. When you get a mortgage on your house, there's usually 10, 15, 20, or 30-year mortgages. And by that time, you will have paid off on the day after your 30th year or your 20th year, you will have paid off your house. And then you own your house outright, not you and the bank own that house. So basically, it's like that. So they have a depreciation schedule, and we pay back PNM for all their big plants. And so the gas depreciation schedule is oftentimes over a 40-year life cycle, they call it. And what PNM came in this case, and they said, we want to, pursuant to really in a way to exceed the ETA, we're going to close all of our fossil fuel productions by 2040. And so we want to depreciate the expense that you pay us and end it by 2040. So by January 40th, by January 1st, 2040, we will have paid all what we allegedly owe PNM for those gas plants. And so New Energy Economy endorses and supports PNM's request to align the depreciation expense for PNM's electric utility gas assets, and there's about 4, I believe, with PNM's terminal dates, they call it. Terminal dates are when they say they're going to close those plants. This will align the actual appropriate customer costs with the benefits received during the time they are used. And it will accurately reflect those costs. And it will also avoid intergenerational inequity. And it will comport with commission rules and public policy. And I want to talk to you about intergenerational inequity. So what that means is when we're using it, when we're getting the benefit of the gas production, that's when we should pay for it. So if we didn't align the depreciation schedule with the terminal use, with the end date of that plant, what would happen is we would stop using it potentially in 2040, but then PNM would still be collecting from customers. Let's say if the depreciation schedule was till 2042 or till 2045, those people who will be paying PNM rates in 2042 or 2043, 4, and 5 will be still paying for those gas plants, even though they're not going to get any benefit. So if you came in to New Mexico in 2042, for instance, you're paying for something that's not even producing any electricity for you. And we believe that that's an intergenerational inequity. And actually, it's a regulatory term of art when you're talking about depreciation, because you want to align the use with customer paying for that time. And so we agreed with PNM, and we agreed with it, and that's how we started off our brief. And I want to explain why we started off our brief that way. Because during cross-examination, I said to their depreciation expert, it was like my first question of him, and I asked him, well, when you had to do your depreciation...
That's okay. You can start with,
when you had to do your depreciation analysis for the utility, PNM, were you instructed by PNM to exclude Four Corners? And the answer was yes. And that's why now we're moving into the question of the Four Corners plant. So I had just explained to you that if we know we're going to close the gas plant in 2040, that's when we should stop paying for that gas plant, because we don't want to create an intergenerational inequity, meaning that people later were going to be paying for something they weren't getting energy from. Well, guess what? When is PNM's current terminal date for Four Corners? It's 2031. When is their depreciation schedule for Four Corners? 2041. Well, that is an institutionalization of intergenerational inequity. Have they moved their depreciation schedule to match their terminal date? No, they haven't. And why? And the reason why is because they want to artificially... There's two things. Hold on. Let me go back.
Yeah, sure.
And the reason why is that even though Four Corners create high rates for customers, they're artificially low. Why? Because the depreciation schedule goes out to 2041 instead of 2031. And if the depreciation rate was paid according to what it should be paid, so that when the plant closes, the depreciation schedule ends, we would pay even higher rates for Four Corners. And what's happened because of that is we're paying artificially low, high Four Corners power plant rates. And the rates that the commission we're told by PNM were just, fair, and reasonable was a lie, was a manipulation, because the current rates do not include all the depreciation. And you know how much is left over at 2031? It's not a little number. It's $300 million. So if we left it the way PNM wants to leave it, people in 2035 who were just born or who just moved into the state will be paying for Four Corners electricity costs, even though they won't even be getting the dirty energy from it. That's ultimately unfair, unjust, and unreasonable, and contrary to commission rules, and is an intergenerational inequity. So why are they doing that? Why did they keep a knowingly false depreciation schedule? They've known about it since at least 2017, which is 7 years ago. The reason they kept it is because they already, as I told you, Four Corners is the second highest rate cost for generation on PNM's portfolio. The highest is the nuclear, which we'll get to next. But the second highest is Four Corners because it's a non-performing plant, because it's 50 years old, because of a whole lot of things, because it requires tons of pollution controls. It's just a terrible, terrible idea. It's not what we call used and useful. It is used, but it's not useful. And the way useful is defined in the law, in regulatory law, is that it's got to be efficient. Well, it's not efficient because it's the highest cost except for Palo Verde. It's the highest cost generation resource on PNM's portfolio. But we already know now, and this is what we learned in this case, is that it was already not useful, and that's another, used and useful is another legal regulatory term of art. And that's what we argued, that Four Corners is not used and useful. But we also know that the rates that they told the commission were just, fair, and reasonable for Four Corners, and the commission accepted in 2017, the last time PNM asked for a rate increase, had a depreciation schedule way beyond its terminal life. And that skewed, that manipulated the numbers to show that even though they were high costs, they weren't high enough to actually pay for the use of that plant in that time period. And then, of course, you all know, and we've been saying, that PNM initially invested in Four Corners without any contemporary financial analysis. And that's a huge thing. Like, would you just go into a house, look at a new house and say, oh, I'll take it without even knowing what the price is? Of course you would never do that. And, you would never we even have a term of art called, when the real estate business, you turn to your realtor and you say, show me the comps. Well, what does that stand for? It stands for the word comparables, which is, I want to see, well, what are the other houses in Santa Fe that have 3 bedrooms and a view cost? Where, I want to be close to this school, not that school, or whatever the other factors that you use to, when you are an adult, we call it discernment. And we evaluate. And sometimes that evaluation is rather quick in our mind, like, what do I feel like for lunch? And you don't have to make a big to-do of it. But sometimes you say, I really want soup right now because it's like cold and rainy and I want to warm up. And so you do have extra factors that you consider. Well, when it's a big decision with a lot of money at stake, there's a lot of factors that the law requires the utility to factor in. And some of that is, well, are there going to be required regulatory risk, like the requirement of pollution controls, or how much water is used? That's a consideration that's very important in New Mexico. The cost, obviously, is a very important consideration. And whether there's climate-altering emissions, like NOx and SOx and methane and all of the horrible things that coal plants emit. But did they do that analysis? The answer is a big fat no. And they didn't do the analysis because at the very exact same time period, PNM was concerned about whether San Juan, its plant, because PNM is the operator of the San Juan generating station. It is not the operator of the Four Corners plant. It's just a co-owner. The operator of the Four Corners plant is Arizona Public Service. And so it had the opportunity to get out of Four Corners in 2016. And it did no analysis. Another co-owner, people are familiar with, is called El Paso Electric, another utility monopoly in New Mexico. And that utility did do the proper analysis. It performed financial analysis, and it also thought about, well, what are the risks involved in signing up, re-upping our what's called a co-tenancy agreement with APS. And what's so significant is not only did it show that their investment in solar and gas, which is what they did do instead of continuing with Four Corners, and they thought, oh my gosh, there's risk from having to put on expensive pollution controls. There's all sorts of other risks that they enumerated. That itself, El Paso Electric's, and there was one other co-owner that also left at the exact same time, Southern California Edison, they left the plant. And that their departure almost triggered the closure of Four Corners. But it didn't trigger in the PNM negotiators' minds to even do a basic financial analysis. And when they didn't do that basic financial analysis, and they signed up without any thought, why? The real reason is because nobody but New Energy Economy challenged them on it. Everybody just looked the other way. New Energy Economy is the only one who raised the question of whether PNM was prudent, acted prudently or responsibly when they signed up without any financial analysis or risk analysis. And in 2017, when we challenged it, we first won. And then we one in front of the commission too. And then PNM was involved in ex parte with commissioners, and they reversed themselves within 10 days over the Christmas holiday. They just reversed themselves based on no new evidence. And they said, you know what? We will scrub the word imprudence out from this opinion. We will kick the can down the road, allow ratepayers to challenge the prudence at some later date at the next rate case. But for now, we'll just accept PNM's use of Four Corners. Well, that was a very sad day for New Mexico and for New Energy Economy, because we had proven that PNM was imprudent. So this hearing that we were just engaged in was another time that we were required to prove up whether PNM's 2016 reinvestment and life extension of that plant was prudent. The continuation. And it's not only that, as I told you, that we're paying high costs, but that plant, if PNM would have gotten out, because EPE, El Paso Electric, is only a 7% owner, and it almost closed because of that. If PNM would have closed, PNM is a 13% owner, and it would have triggered the closure. And if it would have triggered the closure, there would have been less coal ash produced, which is leaking into the San Juan River that native people depend on, native farmers depend on for their water source, for their agriculture, for their animals. So it's poisoning the water, it's poisoning the air, it's poisoning the earth, and has been. And instead it could have been shut down, and we would have had, really what we would have had is brand new solar. It would have been 7-year-old solar, and they probably would have at that time put in a gas plant. But frankly, I just will tell you, even though we don't want gas plants, a brand new smaller gas plant would have been so much better than this huge, horrendous, polluting coal plant. And besides which, we probably would have closed the older gas plants, which are much worse for the environment. And it would cost us, instead of it being the highest cost between both the gas and the solar, it would have been less than half of what we're paying right now for Four Corners. So it's never been cost effective. It's never been efficient. It's always been polluting. And the other thing is, what's crazy, and I spent quite a bit of time in my brief about it, is the goddamn coal plant doesn't even work. It's unreliable. It only works an average in these different years that it's been going since 2016. I think the average is like 72 or 75% of the time. So on top of all those bad things, the thing doesn't even operate at close to efficient use, meaning it can't be relied on to work, and only works somewhere between 72 and 75% of the time. That's a pretty unreliable plant. The next thing, Palo Verde. So in the Palo Verde case, PNM also was imprudent. This was a time when PNM was acting quite, I would say, recklessly. And they didn't do any financial analysis when they reinvested in Palo Verde Nuclear in 2015 or 2016 either. And who caught them? New Energy Economy caught them. Was there anybody else? Not at the time. Later, Albuquerque Bernalillo Water Utility Authority came in, and we acted jointly in many of our efforts, but nobody else. And we said that they were imprudent, and this time the commission found them to be imprudent. Not only the hearing examiner, but the commission. And one of the things that the commission did was they said, hey, you reinvested in this nuclear in part because you wanted to foist future decommissioning liability onto ratepayers. I got to talk to you about this. Today, there is no answer for radioactive waste that is piling up and being held temporarily at all the nuclear plants in the country. Where PNM gets its nuclear is the Palo Verde Nuclear Generating Station in Arizona. It's on I-40. If you ever drive from New Mexico to LA, you go on I-40 and you'll see it. And there's an exit there that says Palo Verde Nuclear Generating Station. It's a long way from Santa Fe, and it's the most expensive form of energy because they want top of the line, computers and all sorts of things, boilers and everything that they need, or whatever they need there. And on one hand, we want to pay those capital expenditure investments because we don't want a nuclear meltdown. On the other hand, it is so ridiculously expensive. It's like 4 times the cost, or maybe even more, of solar, and 7 times the cost of wind. I mean, it's just crazy. It's like double the cost of gas. And it doesn't create one job in New Mexico. It's the most expensive form of energy. And you know how industry likes to say, oh, jobs, jobs, jobs. It literally doesn't create one job in New Mexico. It's the largest nuclear plant in all of the United States. And APS, Arizona Public Service, also operates that. And I think it's going to close early. Because it's so expensive, because it uses so much water. It's the most water-intensive form of energy, of any energy, because they need the water to cool the hot rods, the hot nuclear rods. And of course, we need that water. Why? Because it's so radioactive and we don't want a meltdown. So with Palo Verde, they invested it imprudently without any financial analysis. The commission's remedy or consequence was, hey, guess what? You are not going to foist those decommissioning costs on to ratepayers, PNM. That's going to be your consequence. Well, it went up to the Supreme Court. PNM appealed that. We won everything, but the court found that PNM was not on notice for the potential consequence that the commission meted out. So the penalty, the problem, the remedy that was going to be solved, they didn't think that PNM had enough notice of. And that's a procedural question. So in this case, in this rate case, the commission ordered PNM to do a study and present that evidence to the commission in this rate case. And it said, okay, you want to now have rate. So since 2016, ratepayers have not been paying future decommissioning costs. And that's good. But in this rate case, PNM said, hey, we want to foist that onto you, back onto you. And what the commission had found, by the way, in 2017 was that they said you, PNM, are responsible for future decommissioning costs, no matter what, no matter who it's sold to, whether it's sold to ratepayers or anybody else. So since one of the reasons why you wanted to repurchase those nuclear assets and did so without any financial analysis, that's going to be our penalty. It's the decommission cost going to be on you. And as I said, the Supreme Court ruled that PNM was not given notice of that particular remedy, and so they sent it back. And the commission then ordered PNM to do this analysis. Well, PNM just didn't do the analysis. They just didn't do it. They were basically like, fuck you. We don't have to listen to your order. And they didn't. And what they said was, well, ratepayers would have to pay for decommissioning costs anyway, so why should we do the analysis? So we didn't do the analysis, which is not true, because what the commission ordered was, hey, if you would have instead invested in solar or solar and gas or solar and storage, would the decommissioning costs be the same for those things as they are for radioactive waste that's around for 100 million years? And so PNM just said, we're not going to do that study. We don't want to do that study. It doesn't take rocket science to know that the decommissioning from a solar plant and the decommissioning from radioactive waste that's going to be around for 100 million years is not going to be the same. And so you don't have to be a nuclear scientist or a lawyer or anything. You can figure that out. And so PNM was like, we're not going to do that study. So in our brief in chief, we said, hey, they just ignored the commission. They just blew the commission off. They just said, we're not going to do this. We're not going to follow your orders, even though you're supposed to regulate us. We are not going to do that because we didn't think it was worth it. And yet, we are asking you to make ratepayers pay for future decommissioning costs. In PNM's brief, so this is what I wrote in our response brief. In PNM's brief, they said, you know what, Commission, don't worry your pretty little heads off about future decommissioning costs. Just don't bother. Don't bother making the decision now on that. We withdraw our request to make ratepayers pay. And so don't deal with it. And it's another like super arrogant position of PNM. They were ordered to do the study. They didn't do the study, but they wanted us to pay anyway. And then they had the audacity to say, oh, you know what? You shouldn't make that decision now. But it's the commission who regulates PNM, not PNM who regulates the commission. And so we said in our response brief, no, we want that decision made and we want it to be made now. And PNM should lose because they had a burden of proof to show that their nuclear investment with decommissioning was better off than solar plus storage with virtually no decommissioning or very little. And they didn't do that either. So those are the biggies. The last thing is return on equity. And something really funny happened. It was the highlight, I would say, of the rate case. And this is like a little story that you're told when you're a brand new lawyer. And PNM's lawyer is not brand new. He gets paid about $1 million a year to represent PNM. And this is like one of those things that he should never have done. And I don't know if he was just asleep at the wheel or too tired, because it was literally the last day of the hearing or the second to last day of the hearing. And he got his ass kicked. And here's the story. So he says to this brand new economist at the PRC staff, who's like, I think 24 or 25 years old, really sweet looking, young man. And his name is Christopher Dunn. And this is his first case, and he must be nervous. And so PNM's ROE, return on equity, is at 9.5%, 9.575%. And they want to increase it, despite that their risk is going down. But they say, oh, well, if we increase the ROE, the return on equity, to 10.25, will be so attractive to investors, and investors will want us, and we want investment. And so, yeah, let's up our payment to the richest people on Wall Street just a little bit more. So New Energy Economy said, actually, PNM's risk profile has gone down, and like APS, their sister electric monopoly, and you know by now from listening to this that they're both in Four Corners, they're both in Palo Verde, so they have very similar, they're both really close to each other physically. They have similar, not the same, no utility is the same, but they have similar utility attributes, and you're supposed to look at that. And they were just awarded an 8.9% ROE. And we said if it's good for APS, it's good for PNM. And we had a deeper analysis than that, but that was a definite part of our analysis. You should get 8.9. So PNM wants to raise and increase their return on equity. We wanted to decrease the return on equity. So Rick Alvidrez is cross-examining this young, brand new person at the PRC. And the PRC staff recommended a reduction also, not as dramatic as New Energy Economy, but they said, oh, they should go from their current 9.575 to a 9.4, maybe a 9.45. I don't remember. But it was a 9.4 something. And so Rick Alvidrez first starts out and says, oh, do you know this industry paper? It's it's an investor pamphlet that's sent out on a monthly basis. And are you familiar with it? It's called Value Line, if my memory serves me. And he says, well, of course I do. I know about that. That's, investors talking about ROE and other things like that. Read that. So he says, oh, yeah, well, great. And so he said, did you read the one in April? And he said, no, I didn't read that particular pamphlet. And so he said, let me show you this exhibit. And Christopher Dunn's attorney is going crazy and says, look, this has nothing to do with it. It's not been admitted into evidence. And so Rick Alvidrez is all ready, and he says, well, there's an exception to hearsay, and we're allowed to bring in periodicals that are, of renown, repute. And this witness says he's familiar with that analysis, investor group analysis. And so the hearing examiner says, okay, I'll let you cross-examine with it. So Rick Alvidrez says, okay, sir, would you, Mr. Dunn, read the highlighted portion that is in an article in this value line by some guy who we don't know. And what does it say? And it says, so he said, will you read that highlight? And so Christopher Dunn complies, and it says, well, investors want a 10 to 11% return on equity. He said, so I read that to you, but I just want to say that 2 lines above this, Mr. Alvidrez, not in the highlighted portion, it says the average ROE for Western electric utilities, 35 Western electric utilities, the median is 8.3% ROE. And it was like a moment that you're not supposed to do as a lawyer. You're not supposed to ask them, oh, read one portion, but then exclude another. And it's literally 2 lines above. And so it followed. So their investors' desire to see it go up to 10 or 11% well, that's fine. It's like, hey, I'd like to have a brand new Tesla, but I'm driving an old 2012 Volvo, that's like my situation. Well, so what are the median ROE in Western states is 8.3 ROE. So why even at 8.9, New Energy Economy's proposition in the case was generous because it was more than what the median is for 35 electric Western utilities. And you're supposed to look at what the other ones are as opposed to what a specific desire of an investor is. So that was just like a big sort of oops. And that was kind of fun. And, I don't think that PNM will get that increased ROE. So that's the rate case.
That's the rate case.
If you're still alive and awake after all that, but I hope it wasn't too boring on the rate case. But these are just to wrap that up and put a fine point on it. If we win on the Four Corners case, it could mean a $500 million savings. If we win on the Palo Verde, it could mean north of $138 million. If we win on the ROE, it'll probably be about $10 million per year. So these are big numbers. And so we're fighting because this has an economic justice implication and also climate justice implication for an environmental, for ratepayers. And that's something that is obviously a deep concern of ours. The next thing that we're talking about, and I'll try to be quick, is called decoupling. It's such a crazy thing, and I don't like it. New Energy Economy does not support decoupling. We believe it's corporate welfare, and I'll tell you what it is. Instead of fighting the man and requiring energy efficiency that's just imposed, they just got to do it. The NRDCs of the world and others, but it was really pushed very hard by NRDC in particular. That's the Natural Resource Defense Council. They said instead of fighting the utility, let's make it easy for the utility. We got an idea. We will pay the utility to implement energy efficiency. And as we know, the more PNM energy that's sold, the more money they make. That is how the business system works, the regulatory system. And so energy efficiency is not what the utilities want to do. And they don't do it. They don't do it really. So the NRDC's big idea was to say, hey, in order to incentivize the utilities, some of the wealthiest corporations on the planet, to do what is right, let's pay them. Let's pay them to have energy efficiency programs. So that's the idea, and that's what was passed by people like Noah Long in the 2019 legislature. And so that's the law, and I don't like it, but we lost in there in the legislature. And Noah Long had the ear of Brian Egoff, and they pushed it through, thinking it was such a great deal. Another neoliberal scheme that hurts the poorest ratepayers. And I just want you to know, this isn't just like my idea. There was a study in England in, I think, 2019 that said that rates went up 18% for the poorest people as a result of decoupling. And they did a study of all these states that implemented decoupling. So it's not a good idea. And it basically, and really carbon emissions have not they have not gone down. They've gone up in that same period of time. So it doesn't work. That's a big, important thing. And it costs people more money, and the utilities are making record profits. So it's a failed idea. But it's the law in New Mexico. Is that enough for PNM? Oh no, oh no. We said what the law says is this scheme only is about utility developed programs for energy efficiency and load management. The theory is that if people actually do reduce their energy consumption, that if enough of it happens over many years, we could save building a new coal plant or a new gas plant or a new solar plant even. Because if you don't need as much energy, if you reduce your consumption, then you don't need some of these big plant investments. That's the theory behind it. And we said, okay, the law, even though we don't like it, says PNM, you get paid for your energy efficiency programs. Not for if it's a mild summer and people use less air conditioning, not for tax reform, not for building codes that require more energy efficient appliances or insulation and we need less energy. No, not for that, because that's not a utility program. That's just what I said to the Supreme Court. That's just a vicissitude of the market. That's just something else that happens that has nothing to do with PNM developed program for energy efficiency. But PNM says we want to get cost recovery, it's called, revenues from ratepayers no matter why there's a reduction in electricity. And we said, And we were joined by the Attorney General, and we were joined by Albuquerque Bernalillo Water Authority. We were joined by Bernalillo County. We were joined by the biggest energy consumers like Facebook and others. And I think that we are going to win, like our interpretation of the statute is going to win before the Supreme Court. And I think that the argument went well. And when Justice Bacon and Zamora, who were the most active justices to ask questions, they said, you're not saying, PNM, that you get to recover all the money no matter what the cause, are you? And they said, yeah, that is our position. Yeah, if we have a mild summer, we still, and there's not as much air conditioning use, we still want to recover as if it were the same high energy use that we need, that we need for our revenues. So that's really, in a nutshell, what the case was about. And we said, no, the law only pertains to utility-sponsored programs for energy efficiency and load management. And I think that is what the Supreme Court is going to uphold. But it was a little hard because, like with the Avangrid case, there's a story there. You can tell, you can have good examples and talk about cross-examination and other things like I did with the rate case. But when it's just purely legal and statutory interpretation, it's really less sexy, and these are complex issues. So we are hoping that the Supreme Court is going to do the right thing. I think they're going to do the right thing, and I think that they're going to rule that PNM's extraordinarily broad and super greedy, I know you're not surprised, position and interpretation is wrong.